Hello, everyone. This is Melissa Steinman, and welcome. Thanks for joining us. And this is Consumer Product Safety and Warranties. Just as an FYI, in the middle of the meeting, I will be announcing a CLE code, so keep an ear out for that. And hopefully you'll stay with me, and let's talk. As an agenda, just for scope, so you know, this webinar is going to focus primarily on two areas. The first is the Consumer Product Safety Commission. We're focusing primarily on what's going on at the CPSC and a backgrounder on the jurisdiction, requirements, compliance tips, recent trends, who's coming up as the commissioners, new laws and legislation, but we'll be focusing primarily on consumer products rather than, say, FDA, NHTSA, those agencies. We'll do a little bit on state laws, but scope will be primarily on products within the CPSC scope. Then we will move on and spend the last third or so of the webinar on consumer product warranties and the Magnuson Moss Act, as well as state laws, what's going on in recent litigation in that area, and then the right to repair that's been so in the news lately. But that again will be mostly with consumer products, primarily those Magnuson Moss. It's worth more than $15, but just so you know what our coverage is going to be. The Consumer Product Safety Commission, as many of you hopefully know, is an independent commission, like the Federal Trade Commission as another independent agency. It was established in 1973. It focuses, of course, on the consumer products that so many of us have in our home. Some of the best known, we all know them from product recalls, like baby products, cribs, infant seats, also things like fire extinguishers is one of the big recalls from this year. Or products, premiums, or that sort of thing. There are 5 commissioners on the agency. No more than 3 may be from one political party. Currently, there are actually 3 commissioners, but we should be getting 3 more soon. That's because the acting chairman right now is a holdover. He's finished his 7-year term. And so we're waiting for the 3 new commissioners to be confirmed, including the new chair, Alexander Hohen-Sarek, who was previously the Chief Counsel for Communications and Consumer Protection with the House Energy Commissioner. The other 2 will be Mary Boyle, who is currently Executive Director for the CPSC, so she really knows her stuff. A lot of people at the commission are lifers, so that's not uncommon. We've also got Richard Trumka Jr., who's also coming over from the Hill. He's the General Counsel and Staff Director at the House Oversight and Investigation Committee Subcommittee on Economic and Consumer Policy. It's the chair who really influences the agenda, the budget, and the direction of certain policies. So Adler, Acting Chairman Adler, has been very active on that front, and I'm sure we can expect the new chair to be active on that as well. When we define what's a consumer product, that is defined above. It's any article or component part that's produced for sale to a consumer for use in or around a household or residence, in a school, in recreation, or for personal use or consumption by a consumer in or around a household, residence, school, in recreation or otherwise. So the schools or in recreation broaden that definition a little bit, but what's important also is understand what it excludes, which are usually regulated by another agency. So you've got that list below of motor vehicles, which are the National Highway Traffic Safety Administration, boats, which are the Coast Guard, aircraft, the FAA, pesticides, tobacco and firearms, food, drugs, cosmetics, and medical devices, and just anything that's not used by a consumer. The primary law that regulates or that the Consumer Product Safety Commission enforces is the Consumer Product Safety Act, or the one that amended it in 2008, the Consumer Product Safety Improvement Act. Good name. It's an umbrella law, and it essentially says CPSC must promulgate standards. It requires testing and certification. The CPSC has also created a public database to report consumer incidents that's you can find on saferproducts.gov. We generally recommend that if you make consumer products, you go to that website, you register for it, because if you register, you'll get reports or you'll get notices when there's somebody who reports an incident, and you then get the opportunity to respond and sort of have your say about that incident. That database is, as you can imagine, searched by, say, plaintiff's counsel or the like. So you do want to at least get your chance to respond, because it is public, and also to know who has complained, so that you can consider how to work with that. The civil monetary penalty amounts are very high. We'll talk about some individual cases in a minute, but they can be up to $15 million per incident. Of course, the CPSC has the authority to pursue recalls and even ban products that they think are very dangerous. So, for instance, they have been working for many years to try to ban these tiny or rare earth magnets that you may sometimes see as desk toys. This is a long litigation that some children play with or swallow and have caused considerable damage. Most important that we'll spend some time on is they require mandatory reporting of products that may present a risk of injury or violate a mandatory standard, which is probably what, besides compliance, clients spend the most time on when they receive reports of injuries or the like. So a little bit more about the relevant laws in this area. We've, of course, talked about the CPSA, but there's also laws like the Poison Prevention Packaging Act. Certain household substances have to be packaged in child-resistant packaging. There's the Federal Hazardous Substances Act that require warning labels on certain substances, and also give the CPSC the authority to regulate or ban hazardous substances. There's also the Gasoline Burn Prevention Act, the Flammable Fabrics Act, hazardous materials. There's regulation of art materials in some cases, refrigerator safety, pool safety, drywall safety, nicotine poisoning. So you can see the kinds of laws that can be regulated or enforced by the CPSC, as well as standards that are, say, passed by the ASTM or other voluntary groups that may be used by the CPSC if there's violations, to sort of determine whether there may be an issue with the product. We talked about 15B reports. Section 15B of the Consumer Product Safety Act requires mandatory reporting upon receipt of information that reasonably supports the conclusion that any product over which the agency has jurisdiction fails to comply with a rule, regulation, standard, or ban, or that there is potentially a substantial risk of injury to consumers, or a product that creates an unreasonable risk of serious injury or death. There's also a few specific triggers or statutory violations, such as things like death from choking on toys, or there's poisons or hazardous substances. So those are violations of standards like the small parts standard or the Federal Hazardous Substances Act or the PPPA that we talked about. Violations of those standards, or the presence of an injury or the like that indicates there may be a defective product, may trigger that duty to report. Who has the duty to report? Manufacturers, importers, distributors, and retailers. So really anybody up or down the distribution chain has that legal obligation to report. It may be that a manufacturer has more information and a higher duty to report that information. But even if you're a retailer who receives information that indicates, your customer, a purchaser reports that, hey, this product caught on fire, that will trigger potentially the legal obligation to report. One of the things that's so difficult about this duty is that the language of the law says that you must report immediately upon receiving information that reasonably supports that conclusion, that there's a failure to comply. So immediately under the law means within 24 hours of obtaining reportable information. It's a pretty strict standard. When you drill down into that a little bit more, what immediately means is within 24 hours, but you get 10 days to investigate and determine whether there is in fact reportable information upon getting some information. In addition, there may be an additional 5 days to sort of let things percolate up through the executive decision-making process, and make the decision as to whether there's information that should be reported. So it's 24 hours, but there may be additional time built in there to make your investigation in order to determine whether something is reportable. This is all very important because a failure to report in a timely manner, so late reporting, may lead to a claim by the CPSC for civil monetary penalties, as well as increased compliance requirements. And there have been a number of very significant civil monetary penalty cases over the years, up to and including 2021, for failure to report in a timely manner. So when we drill down and we say, what is there, is there a substantial product hazard? Is there this unreasonable risk of injury or death? This is a pretty strict standard. As we said, first of all, that may be a failure to comply with the Consumer Product Safety Rule. So that's often more clear. The muddy one can be, is there a product defect that creates a substantial risk of injury or death? This is sort of a multi-factored standard or consideration. You look at things like, what is the risk of injury? What is the injury, that's been reported here? What's the risk it will occur? How many injuries have been reported? Is there a pattern here? Is there a pattern of the underlying defect occurring? How many products were distributed in commerce? What's the severity of the risk? Is it somebody just saying, I saw smoke, Or is it somebody who, say, was very seriously injured, had a digit cut off or something like that? So you need to look at all those factors, including things like, was this a reasonably foreseeable misuse of a product? Something like that, you sort of delve into the product liability factors in order to determine whether perhaps there's a substantial risk of injury or death, because that's what the commission will be looking at. But it's important to note that the presence of any one factor can result in a finding that there is a product defect or a non-compliance with the standard that creates a defect or a substantial product hazard. So one serious injury, or even just the risk of a severe injury, or even zero injuries, if we know that risk is there, can be enough to require reporting. The other thing to understand is that, again, we go back to that product's liability analysis. You can have a defect with respect to design, manufacture, or warnings, ultimately. And so the commission will be looking at all those issues when it does its analysis. In terms of the types of recalls, so if you decide that you are required to report, you ultimately can decide to pursue, request different types of recalls, and ultimately the CPSC may decide to pursue one of three types of recalls. So if you come to the point where you decide that a recall is necessary, that there have been multiple reports of injuries, or that there's been a report of a very serious injury that requires that you file a Section 15B report, or even that your own internal testing indicates that there could be an injury, which is how sometimes the decision to report is made, that there have been no injuries with consumers, that something in your own internal testing indicates that there's a potential product defect. So the decision is made to report what type of recall do you, or what kind of, report do you file. Generally with companies, they will file either a fast track recall or a voluntary recall. And the fast track recall is a process that enables companies to file a voluntary recall along an abbreviated process. And by doing this, they're essentially saying, here's our plan for recall. You file it with the express request for a fast track recall and a plan for making the recall. Here's what our proposed remedy is. Here's how we propose to provide notice in a fairly complete format, with the intent to sort of wrap things up along a very abbreviated timeline. There are specific requirements for when you have to have things done, and it's fairly quickly. In that case, what you get for doing it along that timeline is that no determination of a substantial product hazard is made by the commission. The advantage there being that that there's no announcement that there's a product hazard, and there's no that's not out in the record for the product's liability attorneys to use in their favor. The sort of vanilla flavor voluntary recalls, if you will, the full recalls, are maybe company issued, or they may be CPSC initiated, and they will move along a longer timeline, but they may include a preliminary determination that a substantial product hazard exists. So you get more time. They may or may not include that determination that a substantial product hazard exists based on the CPSC's determination. The third kind of recall, which is much more rare, are cases in which the CPSC initiates and sues to force a company to conduct a recall. So that that rare earth magnets situation is a mandatory recall, and it must include a preliminary determination that there's a substantial product hazard. Not every product leads to a recall, as you can tell from the voluntary recall description. Except when a fast track recall is requested, the commission will evaluate the nature of the hazard and make a determination. There are 3 different types of hazards generally. The Class A, which is when the risk of death or grievous injury or illness is likely or very likely, or serious injury or illness is very likely. Then there's Class B, which is when that risk of death or grievous injury or illness or serious injury or illness is likely, or rather is not. Sorry, you can see the standard. Risk of death or grievous injury is likely, but is not likely, but is possible. Serious injury or illness is likely, or moderate injury or illness is very likely. And then Class C, which sort of brings it down a level as to what is likely versus not necessarily likely or possible. So obviously, you get that determination. Or there is always the possibility that the commission will simply close a case without any determination that a hazard exists. In terms of possible remedies, there are a number of different remedies. You always should, if you are the one sort of filing a fast track recall, then you should be proposing a remedy. Otherwise, the CPSC will be involved in determining, and the CPSC may always be involved in influencing what that remedy is. You may propose a replacement. You may propose a repair. You may propose a refund, and there's always an openness to creative ideas, particularly as to how to make recalls easier. Nowadays, we often have our customers' emails or the ability to directly contact them, and that's particularly positive when it comes to the notice side of the recall. It's extremely important to the commission to be able to reach out to customers and to be able to get the products back. So anything you can do in proposing your recall to show I'm going to be able to reach out to reach the customers who have the products in their homes and to get them back is going to facilitate being able to reach this recall plan, or the corrective action plan as it's called, and settle on it. Generally speaking, when it comes to that corrective action plan, the commission is going to require a posting on their website. They're increasingly insisting on something being posted on your social media channels as well, on the recalling company's social media channels as well. And then from there, the general focus is on what kind of remedy, what kind of notice will ensure that the highest level of products will be returned. And if you do not ultimately, particularly if the injury involved is very serious, if you're not able to show that a substantial number of products have come back from the marketplace, then there may be a situation, particularly if there are new injuries in the future, where you have to reinitiate that recall. So it's in your interest to be able to show we have gotten a large proportion of the products that are affected back, so that you can close up the recall. Ultimately, once a corrective action plan has been agreed upon, there will be monthly reporting for a period of time, usually at least 6 months, and sometimes longer, where you say, this is how many, customers we've reached. This is how many calls we got on our 800 number. This is how many, affected units we've gotten back. And then eventually you can request to close the recall, but that will be in part dependent, again, on how many of the affected units you've gotten back. So in terms of data, you can see that the number of recalls have been sort of going down by fiscal year. with the lowest number basically ever in 2019 and 2020. This is going to be, of course, for 2020 in particular, will have been affected by COVID. And there's, if you go to the CPSC notice, webpage, there's a notice that, you know, the recall remedies may have been affected by COVID. But you know, I think that it's probably also affected by lack of resources, you know, particularly under sort of the Trump administration. The budget was down, and I think you're likely to see a much more activist commission in the coming years. So that's something to watch. In terms of more data, only 56% of Section 15B reports end up being a recall. Moreover, if you remove the fast track cases, only 28% end up being a recall. And that's even further reduced when the corrective action does not include the public press release or recall announcement. So the fact that you make a report does not mean that there's going to be a recall. But you certainly want to make that report. And the reason why is because the failure to report cases, as we'll talk about in a bit, are very expensive. CPSC compliance tips. CPSC says compliance policies are very important, and as is the case in a lot of different contexts with compliance policies, they can be a big help if you ever do get into trouble with the CPSC. So you can see from these quotes here, the CPSC in its recall handbook, which is a great resource that's published on its website at cpsc.gov, and really gives a lot of guidance about conducting recalls. The CPSC really emphasizes having compliance policies and programs. They emphasize developing an organizational policy and a plan of action if there is a recall. So that's something they say it's your responsibility to monitor recalls, ensure your business complies with the laws. But the number one reason to have a compliance program is that if there is a violation, the commission will consider whether there is a safety compliance program and system as relevant to a violation. If you had at the time of the violation, a reasonable and effective program or system for collecting and analyzing information, then that will go into the analysis in determining what civil penalties should be. So that's the number one reason to have a compliance program that analyzes what, you know, it shows that you have good testing, you analyze incident reports, lawsuits, warranty claims, safety related issues related to repairs or returns, all that good stuff, because it will help you if you ever run into issues with the CPSC in the future. And that's according to the CPSC. There are a whole lot of other issues. There are a whole lot of other reasons to have a good compliance program, not the least of which is to catch problems before they ever get to the point where you have to report them to the CPSC in the first place. So the goals of a compliance program, first, to design and enforce a system of internal controls and procedures to ensure that all consumer products that you are importing or manufacturing or selling are in compliance with the product safety laws, that you're collecting and recording and reporting that information to the extent that it must be disclosed to the CPSC, that you're making reporting in a timely manner, and that you are bringing to the attention of the appropriate people in your organization any deficiencies or material weaknesses in your design, in the operation of your internal controls, or of course in product design or in process design, so that you are catching them in a timely manner and making appropriate adjustments. In terms of your top 12 compliance tips, what does Yoda say? First of all, assign oversight to an appropriate person in senior management, such as a regulatory compliance manager or director of compliance. So there's somebody with whom the buck stops, who can oversee this. The second is maintain written standards, policies or procedures, so that to the extent that you do have to someday convey this, whether internally to the appropriate people or to the CPSC, you have them written down. The third is communicate those compliance policies and procedures to all applicable employees in risk management, legal, regulatory, marketing, etc., and make sure that you've got regular training programs. You should also be providing an anonymous hotline or an online portal for employee reporting to the extent that there are questions or concerns. You should have a thorough records retention or maintenance system. I would include, we get questions regularly about things like how long to include documents. You should, of course, be following any of your sort of general document retention policies, but generally you should keep things for at least 5 years or the expected life of the product. In terms of what to keep, it should be things like complaints, warranty returns, insurance claims, lawsuits, production records, distribution records, quality control records, and product registration cards, and of course any other sort of similar documents. One sort of special note is data from product registration cards for infant products should be retained for 6 years. And of course, require proper testing and certifications from suppliers, and ensure that your compliance officials are aware of any updated mandatory and voluntary standards. Track product safety and information and incidents, including things like return rates, call center data, ratings by consumers. This is a great area to be leveraging technology. Institute regular reviews, assign a recall coordinator to initiate recalls, maintain a product hold process. This is going to become particularly important if there's a recall, but it can also be important simply when there's design issues or manufacturer issues that are internal and don't necessarily, I mean, there may be situations where you want to put them on hold before things rise to the level of a recall. Plan for a reverse logistics program, so as to be able to identify, isolate, destroy, or return products to the manufacturer. This is going to become particularly important if there is a recall, when you'll have to isolate products and quarantine them as part of the recall. And then, of course, have a post-recall monitoring system before you have to deal with a recall. In terms of recent trends in CPSC enforcement, we talked about how low the number of recalls has been in the past few years. Of course, the Peloton Tread Plus recall got a lot of attention recently. So the new administration has kind of come out swinging with a big high-profile recall. Additionally, there was the recall for kid fire extinguishers, Kitty. I forgive me if I pronounced it wrong, which was a renewed recall for basically a failure to completely recall some fire extinguishers that had failed to work in the past. And there's also the CPSC has brought an administrative action against Amazon in an effort to have Amazon sort of take more responsibility for and track problematic products in its marketplace that are being sold or that are being sold on Amazon. This issue of marketplace liability is sort of a hot issue in both the courts and the CPSC, and is definitely something to watch. Where there's a split in the courts as to whether marketplace sellers like Amazon or eBay or the like should be liable, and how much responsibility they should take for tracking products that are being sold, that are defective, that are being sold over the marketplace. So this is sort of one to watch in terms of products liability issues. We've also seen, we talked about the amount of civil penalties that someone can be liable for failure to report. These are some of the numbers. The Kitty civil penalty was $12 million for failure to report defective fire extinguishers. That was one where there had been a previous recall. These products continued to be out in the marketplace, and so there was a new recall. There was Cybex equipment, exercise equipment, which was a $7.95 million civil penalty, and the requirement to put into place a compliance program. Similar, very large civil penalties in Costco, Echo, Polaris. You do not want to sit on a case where you think you may have the duty to report because the consequences can be severe. Other issues at the CPSC has been paying a lot of attention right now to what the issues of artificial intelligence and machine learning mean. And so that's the idea that an increasing number of products may have artificial intelligence or the ability to learn. So things like the ability to data or algorithms or computations or the like incorporated into the product, and the ability to then analyze or adapt behavior over time. And what does that mean when you've got a product which maybe was one thing when it was put in the marketplace and then changed and operates differently over time? And so they've had forums and discussions with stakeholders on what the implications of products that incorporate this type of technology may be. They published a report this past May on it. They've hired a staff technologist, and they've established a working group on the issue, and are continuing to sort of discuss what the implications of artificial intelligence and machine learning may be. The current recommendations are to continue discussions, engage potentially in voluntary standard setting, and make some product testing recommendations. But this is certainly an issue to watch if you have products that incorporate this kind of technology, because the CPSC is watching it. And they encourage companies that are involved in this kind of technology to get involved in the working group, so that they can have a part in sort of what the agency's position is on it. Additionally, there's some new laws, in particular, the new nationwide upholstered furniture standard, which adopts the California Technical Bulletin 117-2013 as a national law. It was signed into law as part of the Consolidation Appropriations Act of 2020. And that requires specific tests for smoldering resistance. It's a test that a lot of companies, or most companies, should already have been using because it was California law. But it also includes some label size and format and placement requirements. The CPSC recently published an online Q&A last May, and then further clarified it in June to state specifically what was exempted, including baby furniture and some other articles. So that's of interest to people making furniture. And this is an example of the kinds of standards that the CPSC is involved with, and in particular, things like the Flammable Fabrics Act. These standards can also overlap with, say, somebody making furniture would be interested in this, plus the Textile Labeling Act and the the Wool Labeling Act or the like that are enforced by the CPSC. So these are the types of standards that makers in specific industries or manufacturers may be interested in. There's also new legislation of interest. Congress has been very active in this area lately. One new law to watch is proposing that the Total Recall Act, proposing that there should be specific budgets for recall notices. Another that's very important would repeal some of the due process safeguards under Section 6B of the CPSA that require procedural protections before the CPSC discloses information about recalls. So it's really one to watch. We'll see what happens to that. So let's talk about warranties in the last part of the hour. The primary federal law here is the Magnuson Moss Act. The Magnuson Moss Act applies to consumer products or combination sales of products or services. It's intended to ensure that consumers have a written warranty. If you provide a warranty, you must have a written warranty. It is meant to enable essentially comparison shopping, and it provides specific requirements that warrantors must meet. So there's three parts of the rule. The first is the rule on disclosure of written warranty terms, the disclosure rule, and essentially says that all consumer product warranties must be titled, if they're written, must be titled as full or limited. And that if you provide this, then you must provide it in a single, clear, easy to read document. The second rule is what's known as the pre-sale availability rule. And it says that the warrantor and the seller must ensure that warranties are available wherever consumer products are sold. Importantly, I mentioned this before, not required for products that retail for $15 or less. And the third is the rule on informal dispute resolution procedures. So that dispute resolution rule essentially is made, it makes it easier for consumers to take companies to court, but it says that if you use an informal dispute resolution procedure under the dispute resolution rules, there are specific requirements for ADR, such as the warrantor must fund it, must use specified procedures. But if you don't require ADR, or you don't require consumers to use ADR before suing, then you don't have to follow all of those specific procedures under the dispute resolution rule. The Magnuson Moss rule also prohibits specific things. For instance, you're not allowed to disclaim or modify implied warranties beyond the duration of your express warranty. That being said, if you're a seller and you don't offer a written warranty, you can disclaim your implied warranties in most states. Some states do limit the ability to disclaim implied warranties regardless. It also prohibits what are known as tie-in sales provisions. So you can't require use of a specific item or service to keep warranty coverage unless they're free of charge. Or you get a waiver from the FTC. So we'll talk about that a little more in the right to repair discussion. And then, of course, it prohibits deceptive warranty terms. So this doesn't affect things like satisfaction guaranteed or lifetime guarantee statements, although they're going to be regulated to the extent they're deceptive advertising against generally Section 5 generally. So Magnuson Moss does not apply to oral warranties. It does not apply to warranties solely for services, and it does not apply to products sold for resale, strictly for resale or strictly for commercial purposes, although to the extent that you're selling something for sort of mixed purposes, commercial and consumer, then this may be a muddier issue. State warranty laws, all 50 states have some type of warranty laws, although each state, the nature or the scope of its warranty laws may vary. So some states limit themselves to lemon laws and sort of auto warranties. Some focus really on implied warranties. And as I said, they may restrict or prohibit the ability to disclaim those warranties. Some states have warranty laws that apply only to specific types of products, such as cars or RVs, and are meant to provide additional protections to purchasers of those products. And some states have laws that specifically apply to extended warranties or service contracts, which really aren't warranty laws at all, but that's a topic for another day. So to focus in a little bit on a particularly extensive law, California's Song-Beverly Warranty Act is probably the most extensive in the country. Among other things, it says that consumer goods in California are automatically accompanied by certain implied warranties, and then limits the ability to disclaim them. It also requires that if you're providing warranties in California, an express warranty in California, you must have sufficient in-state service and repair facilities, either your own or through authorized independent facilities. So additionally, they have this lemon law provision within Song-Beverly that says that if you fail to repair the product within a reasonable number of attempts, you have to buy it back or replace it. In terms of scope, it applies to any consumer goods except for clothing and consumables. It also is particularly broad in that it has a cost shifting provision. So there's a considerable amount of litigation under Song-Beverly because of the fact that not only is the plaintiff's bar extraordinarily active in California, but there is the ability to recover attorney's fees. So there's an entire bar devoted to Song-Beverly litigation, it seems like, in California. In terms of warranty litigation, there's been quite a bit, both at the FTC and then in the states, and as we mentioned, particularly in California. The FTC has been active in this area lately in two ways. First, there have been some cases, settlements, and warning letters over the past few years, particularly in the 2018 timeframe. The FTC sent out a number of warning letters, entered into a settlement with companies that were marketing and selling automobiles, phones, video games. The concern was that they were tying or potentially tying in violation of the Magnuson Moss Warranty Act. In that cases, they entered into a settlement with a car manufacturer that had been conditioning warranty coverage on the use of their parts and services, which was not an uncommon practice. Certainly to either actually condition it or imply that it was conditioned in that way. So they also sent warning letters to a number of other car manufacturers. These letters warned that the FTC staff had concerns about statements like, "This warranty shall not apply if the product is used with products not sold or licensed by the company." or if the warranty seal on the product, this was in the case of some video games, has been altered, defaced, or removed. With the letters, the request was that the company review the promotional and warranty materials to ensure they did not state or imply that the warranty coverage was conditioned on the specific use of specific parts or services. Now, this has come up more in the right to repair sort of situation now. So I'm going to talk about that since we're running out of time. The right to repair movement has gotten a lot of coverage in the past 6 months or so. The right to repair refers to the right to self-repair or use a third party to repair products without voiding the warranty. And it's become sort of a grassroots, cross-industry, even international movement that's been peaking now. In May of 2021, after a series of hearings, the FTC filed a report with Congress regarding right to repair restrictions, concluding that this was an issue with OEMs, and there were a number of different restrictions like that went beyond sort of suggesting you had to use specific parts, but even to product designs that complicated repair, unavailability of parts or repair information, designs that made independent repairs less safe, policies steering consumers to manufacturer repair networks, application of patent rights, disparagement of non-OEM parts, software locks, end user license agreements, and a variety of other conduct, and that these repair restrictions may violate warranty laws and antitrust laws. So in July, President Biden issued an executive order which asked the FTC to address these unfair anti-competitive restrictions on third-party repair or self-repair items. And the FTC has since voted unanimously to ramp up law enforcement on this in this area. So this can come from, this is sort of a developing issue. There is also legislation making its way through at least 25 legislatures on this issue. So the enforcement and the legislation can come from two areas. The first is sort of MAGMOS or its state law equivalents, the anti-tying provisions there. And we've seen things like the cases from 2018. There's also cases right now, there are class actions against companies like Apple that are claiming that, you know, their products are constructed in a way as to impede repair or self-repair. But additionally, you know, there is the potential for, with some companies, even antitrust cases. And so that's going to be something to watch. We have seen in the EU and the UK rules that were enacted this past year or so that require manufacturers of electrical appliances to make spare parts available to consumers and third-party companies. And the EU is set to expand those rules to cover other electrical devices. Additionally, France actually created a repairability index for companies and required manufacturers to give their products a score based on a range of criteria as part of an anti-waste bill that it passed last year. So different approaches have been taken in Europe with sort of a more environmental, in some cases, sort of bent, as well as these defect class actions that have been filed in some cases against companies like Microsoft and Sony that have included allegations relating to an inability to repair. You know, not necessarily focused on it, but including the inability to repair. So this is definitely a hot issue right now. That is only gaining steam, and the FTC is very focused on this issue, as well as the class action bar is focused on incorporating claims based on product defects and the like, warranty claims. So I think we'll only see more of this. So that's about it. We're over time, or just at time. I think that we do have a couple of questions. I have one on recalls at online marketplaces. I think, is there any advice for online marketplaces and distributors? I think the thing to keep in mind is with online marketplaces is that retailers are responsible in terms of the duty to report. And there are two ways that the retailer can fulfill the duty to report. The first is to actually report and file a Section 15B report. And the second is to write a letter to the manufacturer or importer and copy the CPSC, saying we have received these reports of product defects, and you need to address it. Oh, and so that's two ways to address. I've also been reminded that I failed to share the promised CLE code. So I will do that. Product Safety 2021. So sorry to keep you 2 minutes over before you got the CLE code, but that's one way to get you to listen to the whole thing. Thank you so much for listening. Please, if I missed a question, because I think I missed one, I will provide it to you in an email. Thanks very much and have a great afternoon.